Today, 17th Endowment Lecture on Penal Laws by Honorable Justice Sunder Mohan. And this lecture series is under the S.Viswanathan and B.R.Dolia Lecture Endowment Trust in coordination with Madras Bar Association. And so far as Justice Sunder Mohan is concerned, Justice needs no introduction. Penal laws. Today, penal laws are essential for maintaining order and justice within a legal system, providing a framework for investigating, prosecuting, and punishing those who violate the law. Penal laws have existed in various forms throughout the history and across different societies, often reflecting the values and priorities of the time. The Indian Penal Code, now replaced by the Bharatiya Nyaya Sanhita, the Code of Criminal Procedure, now replaced by the Bharatiya Nagarik Suraksha Sanhita, and the various state and central acts addressing specific offences are examples of penal laws in India. I am not a criminal lawyer. With these few words, I would like to request A.L. Somaj, senior advocate and a trustee of the B.R.Dolia Trust, to say a few words about the trust.
Justice Sunder Mohan, President and other office bearers, my co-trustee Mr. J. Maslamani. Many of you may or may not know about S.Viswanathan, I am sure about it, but B.R.Dolia, at least you would have heard of him, and some of you may know him. S.Viswanathan was a lawyer turned businessman, and he was mainly practicing on the labor law side, along with R. Venkatraman, the then our former President of India. He had a very illustrious career, and he appeared in a matter against the Seshashayis, and the old man Seshashayi, who is no more now, who established this organization, was so much impressed with his arguments, he requested him to take up employment with Seshashayis. Mr. Viswanathan consulted, late Viswanathan consulted R. Venkatraman, who suggested you just try for 2 years. If it is all right, you are able to get on with him, and Mr. Seshashayi is able to get on with you, then you can continue. Otherwise, you can go back to practice. But fortunately, he was successful even in business. He established Seshashayi Paper and Boards, Neyveli Ceramics and Refractories, high energy batteries in Trichy, and we wanted to start something in his name. Mr. B.R.Dolia was concerned, he was a junior of S. Viswanathan, and he was also a junior of M.S. Venkatraman, under whom Viswanathan also was one of his juniors. So in the name of both, we wanted to establish the trust, and this is the 17th lecture series, and I am very happy Justice Sunder Mohan has condescended to accept our invitation and give the lecture. It is in the fitness of things he delivers this lecture, because his father, S. Sundar, was closely associated with B.R.Dolia, and I am very happy that he is delivering the 17th lecture. Thank you so much.
I request a senior advocate Dishonesty to honor the judge with a shawl. Now I request G. Masramani, Senior Advocate and former President of the MBA, to honor the judge with a memento. Now I request the Honorable Judge to deliver this.
Respected senior advocates, Mr. A.L. Somyaji, Mr. G. Maslamani on the dais, and other senior advocates off the dais, President, Bar Association, and my dear friends. I'm extremely happy to be here and also highly privileged to be invited for delivering this 16th S.Viswanathan and B.R.Dolia conducted by the S.Viswanathan and B.R.Dolia Lecture Endowment Trust along with the Madras Bar Association. As my learned senior said, Mr. S.Viswanathan was one of the seniors of Mr. B.R.Dolia. We have a library section in the name of Mr. B.R.Dolia, who was my father's senior as well, as also Sir's senior. So I haven't met Mr. S.Viswanathan, but I've heard a lot about him from my father. Of course, I've interacted with Dolia sir a number of times. I called him Dolia Mama. I've interacted with him a number of times. I can vividly remember two instances which I thought I'll share with you. There were frequent get-togethers in his house those days. I don't know if Mr. Jayesh follows that. If he follows that, at least he has not invited me. So there was a tradition in the office that we had frequent get-togethers. So the first time I remember going to his house was when I was in the 5th standard or 6th standard. So I entered the house and I see people falling at his feet. All guests, whoever entered the house, for the first thing they did was fall at his feet. So I was wondering who this man was. What is this man? Everybody is falling at his feet, and what is it about him? But I was hardly 11 years old. Then I came out of the house. I saw this board outside the house. It said, Shri B.R.Dolia, BSc, in brackets HONS. I didn't know what it meant. Then BL, HONS. I didn't know what it meant. Yeah, I know. Those days I'm saying. Of course, now I know. Those days I didn't know what it meant. And I told my dad, I asked my dad what it was. And he said, honors means this. Of course, I didn't understand what it meant at that time. Then I told my dad, if at all I study, I do, after a degree, please, I want to do this degree. So that I didn't know that, I thought that if you do that degree, you can become like him. So I said, I'll only do this. So that was the first interaction I had. And the second time was after I joined law, my father had to undergo a bypass surgery immediately after I finished my 12th or around 1st or 2nd year of my law. So I had to drive his car to the court. So in the process, I used to be in the chambers. So on one occasion, you had this iron roller connecting chambers. 29 and 30 were connected. Were open. The door in between was open always. So you could go from 30 to 29. Now, of course, it is closed. So he called for some junior. Nobody was there. So he said, nobody there, then bring a paper. He started dictating a plain. So the very first dictation I took was from him. That was a plain. So it was very fast. So I couldn't make out what. So I said, Mama, I used to get irritated. Don't ask, you have to write what. Because the thought flow is getting cut for him. So I somehow managed to write something. I remember I would have only reproduced about 25% of what he dictated. Those days there was a tradition, at least what my father followed, when he dictated a plaint. The facts were dictated by the senior, and the juniors are supposed to fill up the cause of action portion, and prayer, if it's a simple money suit, prayer by the juniors, and if it is a complicated prayer, then of course the seniors will dictate. So so he left it to me, the cause of action. Already what was there was only 25%. So I told my father, I can't go and give this draft to him. I'll be finished. So my father took the pre-suit notice, and then he managed a plaint, and we somehow managed a plaint and gave it to him. These are experience that I had with him. So he was a doyen, as everybody knows. Even if you did 5% or 10% of what they achieved, you would still be a successful lawyer. That was a kind of achievement they had. Now, secondly, what makes me happy to be here is to be with all of you once again. And this criminal law always fascinated me. So I thought I'll share some of my views on criminal law. There are several misconceptions and errors committed by many of us, including some of us judges, lawyers, while appreciating the penal statute. So I thought I'll share some, or I'll try to dispel some of the wrong notions. Before that, let us see what the great judge, Justice Krishnasamy Reddy, said about administration of criminal justice. He was a very popular judge. Most of you may not know, but he retired in 1976. He was a public prosecutor, and then he became an advocate general, retired in 1976. So I had an opportunity to assist my father in an arbitration which was where he was the arbitrator, sole arbitrator. So I had an opportunity to interact with him. In fact, he gifted a watch to my father. I think this is that watch also. So he was very popular. Just to give you an idea of how popular he was, this is what Mr. S.Viswanathan said in his farewell speech, quote, "Your Lordship, Mr. Krishnasamy Reddy, my lords, last week an advocate came to me and asked me if I would kindly request the Honorable the Chief Justice to hold this meeting in the beach. I thought it is a good idea, though I did not like sands getting into my shoes." So the lawyers wanted the farewell to be in the beach, so they expected that kind of a crowd. So he was so popular. So this is what Justice Krishnasamy Reddy said about the administration of criminal law and the search for truth. This is again in response to the farewell address by the learned advocate general. "It is gently said, gentlemen, that," quote, "it is gently said, gentlemen, that it is easy to administer criminal law. In one respect, it may be true. In this branch of criminal law, you do not have much of brain sweating, arguments on technicalities and procedures of law, and hair-splitting intellectual feats. You do not have subtleties and niceties of the interpretation of law and meaning of legal words. There are no frequent citations or precedents and case laws for consideration by the court. However, the criminal law is the most important branch of the law of the country, as it deals mainly with law and order, which affects the administration of which affects the administration, which affects the community as a whole. Similarly, it affects the liberty of the citizen. Therefore, the administration of criminal law requires a great insight into the human problems, abundant experience of human affairs, and above all, robust common sense with a passion to do justice. It is significant to note, this is what he quotes Lord Atkin, what Lord Atkin advised Lord Denning when he became a judge. He said Lord Atkin had returned to Lord Denning when the latter had assumed his office in 1944. He had written in his letter, quote, this is Atkin's words, "I sometimes say to a new judge, don't forget that the most important and often the most difficult part of the work is the criminal work." So this is what Atkins told Lord Denning, and Justice Reddyar said in his farewell speech that criminal law is the difficult part, though we don't have niceties of law. Why is it difficult? So he said sometimes we have to search for the truth. Very difficult because it is you can't convict an innocent person. The Blackstone said that even if you acquit 10 guilty persons, you can't convict one innocent person. Jeremy Bentham said this is the most abused maxim in criminal law. So generally people tend to acquit people left, right and center because misusing or abusing this maxim. But yet he said convicting an innocent person is a greater evil than convicting acquitting. So he said acquitting a guilty person. So therefore he says it's very difficult to administer criminal law. There are many fallacies that we all suffer from. We succumb to this fallacy called the fallacy of begging the question. What does this fallacy mean? A fact that is supposed to be proved is assumed to be correct or true. Generally, this is a fact that is supposed to be proved, and we normally assume that to be true. This invariably happens in any criminal case. There is a crime. The policeman says there are 5 people who have committed this crime. The crime is established. You automatically presume that these 5 persons did this crime. So otherwise there must be some human agency who contributed to this crime. Therefore that is presumed. The illustration of this fallacy is stated like this. A person says, this sweater will keep you warm because it has high wool content. Now this statement assumes that high wool content will keep you warm. This is supposed to be proved. This is what happens in criminal law. So therefore he says it's very difficult to administer criminal law. So therefore, what is it that how is it that we should appreciate criminal law? To borrow the words of Justice Nariman, we will have to begin at the beginning. So for us the beginning is the Bible of criminal law, the Penal Code. Most of you know that it was drafted by Lord Macaulay. The first draft of Penal Code was published in 1837 when Lord Macaulay was the chairman of the drafting committee. This draft was sent to all the presidencies, to judges in all the presidencies, Bombay, Calcutta and Chennai. They all gave their comments. In 1844, they had given their inputs. The Governor General and Council collected all the inputs and then gave it back to the drafting committee to collate it and then make whatever corrections is possible. Then a lot of corrections went in. Then ultimately, Sir James Barnes Peacock, nobody talks about him, he is the one who actually finalized the draft and then he became a law. So you will find lot of differences between the first draft and the second draft. The basic structure was given by Lord Macaulay and then the final draft was prepared by Sir James Barnes Peacock. What is the pattern? The common felonies like murder, rape, dacoity, etc. were common. Throughout the world it is their offences. But there are certain misdemeanors, minor offences. What was an offence in A province was not an offence in B province. So they found it very difficult to categorize acts to be termed as criminal acts. So they followed the Louisiana Code, the Napoleonic Code, etc. And also he took inputs from the judgments of the common law courts to draft this penal code. So what is the pattern? How did they then categorize certain acts to be crimes and certain acts not to be crimes? As I told you, the first draft came in 1837. There were about 24 chapters, like the penal code that we had. They had 24 chapters. Chapter 20 was offences relating to marriage. So in a note appended to that chapter, they made this remark. So this gives you an idea as to how to appreciate the penal code. I'll just read it for you. This particular note was incorporated or was incorporated in one of the judgments of the Apex Court, which is reported in 2016 7 SEC 221. This is Subramanian Swamy was the Union of India at paragraph 90. Quote, this is, I am quoting what the framer said. We cannot admit that a penal code is by any means to be considered as a body of ethics, that the legislature ought to punish acts merely because those acts are immoral, or that because an act is not punished at all. It follows that the legislature considers that an act as innocent. Many things which are not punishable are morally worse than many things which are punishable. The man who treats a generous benefactor with gross ingratitude and insolence deserves more reprehension than the man who aims a blow in passion or breaks a window in a frolic. Yet we have punishment for assault and mischief and none for ingratitude. He says ingratitude is morally worse than giving a blow, but yet we don't have an offense for ingratitude, but what we have an offense is for assault. The rich man who refuses a mouthful of rice to save a fellow creature from death may be a far worse man than the starving wretch who snatches and devours the rice. Yet we punish the latter for theft and we do not punish the former for hard attendance. So again he said, we do not go by immoral acts. We did not make all immoral acts as an offense. We followed a pattern. What is that pattern? There is no indication explicitly as to what was the pattern followed by them. But there is, you can find in certain provisions that indication. Therefore, immoral acts were not punished. Acts which were far more immoral were not found to be not made penal. Lesser immoral acts were made criminal acts. So the indication that you will find is in section 44 of the Indian Penal Code, which defines the word injury. Injury says anything that is illegally, harm that is illegally caused to a man's body, mind, property or reputation. That is injury. Harm caused to a man's body, property, mind or reputation. So any person who with a culpable mental state causes harm to a person's body, mind, property or reputation, that they categorize as offences. So we have culpable mental state, mens rea, body, offences against body, we have offences against property, mind like criminal intimidation, etc. Then reputation is defamation. So these are the broad ways in which they call this an offence. Then we have two other artificial institutions. Institutions that were created were not artificial, institutions were created by man himself. One is state, to protect, to administer the people. The other one is the institution of marriage. So they said, we will protect these two institutions. That is why the offences against state, you will find corruption, you will find waging war, etc., etc. Institution, they had to protect the institution of marriage. That is why if you find in the offence of adultery, the wife will not be punishable. The act committed by the wife is not punishable. So they wanted to protect the institution of marriage. Therefore, the person who intrudes into the marriage was made an offender. Now, if you make the wife also an accused, the marriage is broken. So the idea is to protect that institution. That's why they didn't have. Now, we have this 498A which is brought into the chapter. I think it's wrong place to put that provision, because chapter 20 was not meant for that. Chapter 20 of the Penal Code was not meant for that. So this is the basis on which they drafted the Penal Code, and they have a beautiful pattern. Now, why is it that I say that definitions are important? As I told you, murder is a universal felony. It was never an innocent act. Any part of the man's civilization, it was never an innocent act. But you will find the definition of murder is different in various jurisdictions. In US, definition is different. In India, definition is different. We have murder of the first degree, second degree in US, then manslaughter, which is similar to our culpable homicide. So therefore, what is important is the provisions and the definitions of the offences. In many provisions, you will all have seen the word voluntarily. In many provisions, whoever voluntarily causes hurt. Sir, can any junior here tell us what do you mean by voluntarily? Anyone? Let's just make an attempt. What do you mean by voluntarily that is used in Penal Code in many provisions? Tanaga. So this is the general meaning. This is general meaning. He is right. Many people understand it that way, on own volition. Many people understand that word as on his own volition, voluntarily. But you see, Penal Code gives a different meaning to it. That is found in section 39 of the Penal Code. What does section 39 say? A person is said to cause an effect voluntarily when he causes it by means whereby he intended to cause it. Intention. So voluntarily actually is the mens rea. It tells about the mens rea required for the offence. So a person is said to cause effect voluntarily when he causes it by means whereby he intended to cause it, or by means which at the time of employing those means he knew or had reason to believe. So he knew means knowledge. This is the second mental state that the Penal Code contemplates. Either if you commit an offence with the intention or with the knowledge, then it is an offence. So these are two mental states that we have so far seen. Then the third mental state, they say, is or had reason to believe to be likely to cause it. So these three mental states are there in most of the offences. Now, intention, we know, wanting to do an act. Knowledge. And then we have reasons to believe. You will find all these three mental states in the offence of defamation. If you publish something which is defamatory, knowing that it will defame him, or with the knowledge or with intent to defame him, or having reasons to believe that it is likely to defame him, then it's an offence. So all these three mental states are found in only one offence, that is the offence of defamation. Now if you see 323, it employs the word voluntarily. They specifically exclude reasons to believe. Knowledge and intention alone are the two mental states. What is the difference between intention and knowledge? Intention is supposed to be a graver mental state than knowledge itself. Supposing you go on a shooting spree in a crowded place, you have knowledge that it is likely to cause death, but you don't intend to cause the death of any particular person. So you will see that knowledge is, for example, in a culpable homicide not amounting to murder, if you do it with knowledge, the offence is the lesser sentence, so it is less graver than intention itself. So intention is graver because you have the knowledge that this is the likely result and you still want to do it and aim at a particular person. So many of the provisions don't make any distinction between intention and knowledge. They treat it on par. The punishment is the same for whether you do it with the intention or with the knowledge. But only difference is in culpable homicide, where there is a slightly lesser punishment provided. Then what then is reasons to believe? Reasons to believe is even lesser. You neither intended nor you knew it. Reasons to believe is something higher than doubt or suspicion. So this is what the courts say. Reasons to believe is neither intention nor knowledge, higher than doubt or suspicion. Supposing a man walks into your house at 12 o'clock in the night and gives you some jewels, saying that I'll give you these jewels at half the price. He doesn't tell you that it's stolen, but you still can infer, a reasonable man can infer that it could be stolen. So this is reasons to believe. He doesn't directly tell you that it is stolen. If he tells you that you gain knowledge, it is awareness, but if he doesn't tell you, you have reasons to believe that it is stolen. So this is the distinction they make about the three mental states. Now there are two other mental states that is provided in the penal code, which is rashness and negligence. All of us know negligence. Negligence means you have a duty an omission to do something which a reasonable man guided upon those considerations which ordinarily regulate the conduct of human affairs would do, or doing something which a prudent man would not do. This is a broad definition of negligence. Negligence is both a tort and a crime. What is punishable under the penal code is gross negligence. It's not just negligence, because it's both a tort and a crime. What is punishable, what is culpable negligence is something called the gross negligence. What is gross negligence would depend on facts and circumstances of the case. Again, we have another mental state provided, is rashness. Rashness is you are aware of the impending danger, but yet you proceed with the assumption that that will not happen to you. So many people link rashness with speed. That has nothing to do with speed. Speed and rashness are not necessarily they don't necessarily go together. It can be, sometimes you can be fast and still be rash, sometimes you can be slow and be rash. So rashness in a vehicle, I'm saying in a motor. So in general parlance, rashness is something you are aware of the impending danger and then still proceed with it, and these are the some of the broad mental states that is provided in the penal code. And interestingly, you will find there are two other words used in penal code which are used in all property offences. One is dishonestly and fraudulently. All of you might have seen, invariably you will find these two words being used in all the provisions, all the property offences except for theft. Now in the old draft, this word dishonestly was not there. What was now shown as dishonestly was the definition for fraudulently. There was only one word defined in the old code, and what is now shown as the definition for dishonestly was the definition for fraudulently in the old code. Now after Sir James Barnes Peacock came, he split it into two. He said we have to have two words. One is dishonestly and fraudulently. Now dishonestly, there is no difficulty in understanding the provision. We have what is dishonesty is defined in section 25, wrongful gain to one person, wrongful loss to another person, etc., and that is very clearly defined. So it has some monetary aspect to it. So the word fraudulently, the courts found it difficult to interpret for a very, very long time. They didn't know why. If every property offence could be covered under the word dishonestly, why should then there be a word for fraudulently? Then there was this case, which is the Dr. Vimla versus State Administration. This lady was a doctor. She bought a car in her daughter's name. It met with an accident. Insurance claim was made in her daughter's name. She signed on her daughter. She signed as her daughter, and then submitted the insurance claim. The insurance company rejected the claim, saying that you forged the signature of your daughter, therefore we will not accept your claim. The defense taken by the Dr. Vimla was, there is no loss cost to you. In all property offences, whether it is forgery or cheating, etc., there must be some loss cost to you. Any case, you would have, even if my daughter had signed, you would have accepted the claim. It is not as if I faked an accident, so it is not a loss cost you. So the company said, you would not have caused monetary loss, but you have done it fraudulently. So then they had to go into this question as what fraudulently meant. Till then, they didn't know what fraudulently meant. 1960, can you imagine? 100 years, this could not be defined. The Act actually provides for a definition. It means intent to defraud. They didn't know what defraud means. So then they defined it. They said deceit and injury. In Vimala's case, it is beautifully defined. They defined it as deceit, and by that deceit, if you cause an injury. Now, one injury is already there in dishonesty. That is, injury in the form of causing harm to the property is there in dishonesty. So they said other types of injury will fall within the definition of fraudulently. Then what then is deceit? They said making a false statement or concealing a fact. That is deceit. If you conceal a fact or make a false statement, which is a positive false statement, or conceal a fact, they said it is deceit. And then they said by that, if you cause any other form of injury that is defined in the word in the section 44, other than the loss to the property, that we'll call it as injury, fraudulently. So penal code, which was drafted with such great care, also had to undergo all this interpretations, and it took nearly about 100 years for them to interpret section fraudulently. That the another aspect that gave trouble to the courts was the word attempt. As you all know, all of us know, the crime has 4 stages. We had mens rea, preparation, attempt, and the actus reus. All of us know that is the basics that we learn in law college. Now, preparation is not an offence at all, except for a few exceptions. Preparation to wage war, let us forget the exceptions. Now, the difficulty was in making a distinction between whether in ascertaining whether a particular act was preparation or an attempt. They initially followed the locus penitentiae principle. What does it mean? If you are at a point where you can retrace your steps, reconsider and retrace your steps, then you are still at the stage of preparation. If you have crossed that stage, you can't take back or you can't retrace your steps, then it's the stage of attempt. This was the first simple definition of or simple test for determining whether it is an act of whether it is preparation or attempt. Now, if you find you will find in section 307, which is attempt to murder. In that provision, you will nowhere find, except for the heading part, you will nowhere find the word attempt in that particular provision. But this locus penitentiae principle would be incorporated in that particular provision. Now, the difficulty was not with interpreting section 307, which incorporates the simple test of locus penitentiae. For example, you stand near a well, wanting to commit suicide. You don't know, you've still not jumped into the well. At that stage, you are still at the stage of preparation. Attempt to commit suicide, you can't be charged for attempt to commit suicide. If you jump into the well and you are saved, attempt to commit suicide, you can be charged for attempt to commit suicide. Now, this is a very simple test. For 307, it makes it very simple, or for even 309, that is attempt to commit suicide. But the difficulty arose in interpreting attempt in other aspects, other provisions, especially when interpreting section 511. 511 interestingly says, now just remember this locus penitentiae said, what did I say? It is the penultimate act before the final actus reus. So in 511, very interestingly, it says whoever attempts and does something towards the commission of the offence. So if attempt is already towards the commission of offence, why did they add this word and does something towards the commission of the offence? So 511 gave them a lot of trouble. So what did they mean by attempt in 511? If and in 307 it says it's a penultimate act before the act is rehearsed, which means you're already into the act, you just failed, your attempt failed, therefore it's an attempt. But in 511 says what is punishable is you must attempt an act and do something more to commit the offence. So this gave them some trouble. So interestingly, they then said it's very difficult to define attempt, and I'll just quote the words, very interesting as to what they said about attempt. I'll just take 5 more minutes. This is in 1881 and the penal code came in 1860, and they're still attempting to define attempt. You just see para 20, this is what they said. An attempt to define attempt has to be a frustrating exercise. That's a case where a person wanted to smuggle goods outside India. He was carrying some goods to the ship, and on the way he was intercepted by the customs. He took a stand saying, I could have taken a U-turn. I was still at the preparation stage. You can't call this an attempt. You intercepted me, you can't call this an attempt. Then they said, no, this is ingenious argument, we will not accept. They said that it is not the penultimate act alone in terms of the physical act, it is your intention that matters, and this is what they say. An attempt to define attempt has to be a frustrating exercise. Nonetheless, a search to discover the characteristics of an attempt, if not an apt definition of an attempt, has to be made. Let us now state the result of the search and research. In order to constitute an attempt, first, there must be an intention to commit a particular offence. Second, some act must have been done which would necessarily have to be done towards the commission of the offence, and such act must be proximate to the intended result. The measure of proximity is not in relation to time and action, but in relation to intention. So they said, you intended to smuggle, but for this interception you would have definitely taken it, but therefore your intention was there. It is not the physical act that is important. So ultimately they find him guilty of attempt. So then they ultimately said, what is an attempt would depend on facts and circumstances of each case. So as I told you, what is important is in negligence it must be a gross negligence. This again you will find in Jacob Matthew's state of Matthew, because negligence is both tort and a crime. So what makes a distinction between negligence as a tort and a crime is found in Jacob Matthew's case in 2005 6 SC. They say the essential components of negligence are 3. One is duty, breach and the resulting damage, and what makes it culpable is it has to be gross. The word gross has not been used in section 304A IPC, yet it is settled law that in criminal law negligence or recklessness to be so held must be of such a high degree as to be gross, and therefore the expression rash or negligent act as occurring in section 304A has to be read as qualified by the word grossly. And we often come across this proof beyond reasonable doubt. Where did it come from? We borrowed it from the Wilmington's case. Our Supreme Court adopted that, and now the recent Supreme Court says that proof beyond reasonable doubt. Can you entertain any doubt and then acquit? No. They say what actually it means is, if you are sure of this particular, it is unlike preponderance of probability that we have in civil law, you must be absolutely sure that this fact existed. And what they say is, you must be morally certain that this fact had occurred or this occurrence had taken place. And they use the word moral certainty. It has nothing to do with moral principle. Don't confuse with the moral convictions. They say with moral certainty, if you are able to ascertain a fact, then you can render a finding of guilt. So I think with this I'll stop. I'll not detain you for more time. Thank you so much for this opportunity.
Very short and sweet. Good lecture by Honorable Justice Sunder Mohan. One more information about Justice Sunder Mohan. He is a very good tennis player. One day I went to Gandhinagar Club by 6:30. வண்டி நின்றுருந்தது. அங்கே செக்யூரிட்டி கார்டு கேட்டேன், யார் வண்டி தெரில சார், ஜட்ஜு வந்திருக்காருன்னு. சார் உள்ளே போய் பார்த்தா he was playing tennis in the Gandhinagar Club. Again on some other day I went to race club. கிளப்புக்காக ஏன் போகிறேன்னு கேட்காதீங்க, இல்லை அவர் விளையாடுறத பார்க்க போனேன். ரேஸ் கிளப்பில் வந்து he was playing he was representing the presidency club, I believe, and he won the inter club tournament for the presidency club. So with these few words I request the secretary to give a vote of thanks.
Honorable Justice Sunder Mohan, our beloved and most revered senior advocates G. Masilamani, A.L. Somayaji, trustees of the Viswanathan and Dolia Endowment Lecture Trust, my dear friends, senior advocates and young lawyers, and first of all, we have to thank the judge very wholeheartedly for the simple reason, in spite of his busy schedule, he was sitting in the first bench, he just had other work, but he readily agreed, not only agreed, he made so much of preparation and came and delivered this wonderful lecture, for which he needs a very big round of applause. We all know he's highly erudite and also meticulous in way of functioning. So for that, we are all really happy that we have a very good judge amongst us. And this lecture would have thrown you a lot of lights. And I think this is not sufficient, because I think abruptly he stopped it. I request Judge this to continue, and you will have to give one more lecture on some other day. But still, we request your Lordship to give one more lecture on some other day. With these few words, anyhow, I thank the trust also for having cooperated and coordinated with us for delivering this lecture. And we'll have more such lectures in future. All of you, please do attend in the lectures whenever it's conducted. Thank you one and all for having come here and attended. Thank you so much.